How it should be done and how it should not. How it should not. Roe versus Wade. Two quotations. Reading law. In Roe versus Wade, the Supreme Court declared unconstitutional state statutes that in no way contradicted any specific provision of the Constitution, close quote. Second quotation, Justice Blackmun, 1973 opinion itself. The right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty, or as the district court determined in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy, close quote. So Justice Blackmun, writing for the majority, takes pains to ground the court's decision, well, I suppose you could, in the 14th and the 9th, or if you read his opinion carefully, it's the 14th or the 9th. You get to choose. And he's wrong.
Did he say the 14th? Or
he said
did he say
the right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty, as we feel it is, or as the district court determined in the 9th Amendment's reservation of rights to the people.
Well, once again, this is one aspect that the book addresses. When you have terms in the Constitution that are not ambiguous in the sense that they can mean one of two things, but rather are general, so that they could cover a lot of things. You should interpret them not to cover the things that the people who adopted that provision did not think they covered. And, you know, cruel and unusual punishments is one. Of course, those words could cover a lot of things, but it's clear from the history of the times that nobody thought that it included the death penalty. Nobody. And it's the same thing with this right of abortion, whether it's founded in the 14th or, I mean, God, the 9th Amendment, forget about it. Nobody ever thought that, I mean, just look at history. All the states had prohibitions on abortion for hundreds of years. So when was it that the American people made the decision to forbid a state from adopting such?
They never did.
They never did. The court made it up. And you know, we're not talking about the right or wrong of the substantive result. I mean, I'm quite, you know, neutral on that. The point is, who should decide? Should it be a question on abortion, whether people try to persuade each other that there ought to be, there oughtn't to be, and put it to a vote? That's fine. That's, you know, if you want the right to abortion, create it the way most rights are created. In a democracy, you persuade your fellow citizens, pass a law. You want to abolish the death penalty, the same thing. But all of that democratic choice is taken away when the court is enabled to give vague provisions such as due process of law, equal protection of the laws, meanings that they did not have when they were adopted.
How it should be done. 2008 case of District of Columbia versus Heller, in which you wrote the decision upholding the individual right to possess firearms, a decision that runs to more than 60 pages of very close textual and historical analysis. Reading law, quote, "The Second Amendment did not say that the people shall have the right to keep and bear arms, or even that, quote, the government shall not prevent the people from keeping and bearing arms, but rather that the right of the people to keep and bear arms shall not be infringed." This triggered historical inquiry. So how does the history inform the reading of what strikes a layman like me as a very tricky text, that prefatory clause, comma?
Well, that passage you read triggered, I said it triggered historical inquiry because the Second Amendment refers to it as though it were a pre-existing right. It didn't say the people shall have the right, or even the government shall not take away arms, but rather the right of the people to keep and bear, as though it was a pre-existing right. And that triggered historical inquiry that takes you back to the English Bill of Rights, which sure enough contained the right to keep and bear arms. As for the prologue, are they going to know what the prologue is? You know, a well-regulated militia being necessary for the defense of a free state, comma, the right of the people to keep and bear arms shall not be infringed. Again, if you studied history, what's the connection between not taking away arms, the right of the people to keep and bear arms, and the militia? It seems very strange. But historical inquiry shows you what the connection is. The way the Stuart kings, the Catholic kings, destroyed the militia, which was supposed to be all of the male citizens trained to arms. The way they destroyed the militia was not by abolishing it. They just took away the arms of all of those who opposed the Catholic kings. And so there is a connection. A well-regulated militia being necessary for the defense of a free state, a militia consisting of all of the body of the citizenry, the right of the people to keep and bear arms shall not be infringed. It makes thorough sense if you understand the history. And without the history, you ask yourself, what is this guarantee of the state's ability to have a militia? What is it doing in the Bill of Rights, for Pete's sake? Why isn't it some other portion of the Constitution?